right, let's bring in a defense attorney who knows how these things go, for real, not just on Twitter, all right? Sara Azari. Sara, thank you very much. And look, the judge is making the right point. I have everything. I'm the one determining probable cause. And, you know, there's probable cause times a gazillion for this case to go forwards. But when you look at the plus minus on what should come out and what not, how do you see it?
Well, Chris, look, we're at a preliminary hearing. We're not at trial. So with respect to that transparency that Alex just reported on, that will come at trial. But, you know, at this point, I think this preliminary hearing is a hearing for the prosecution to bring in sufficient evidence of probable cause that this defendant committed the crime, and that's going to get considered by this judge. However, you also have to consider, as this judge, the defendant's right to a fair trial, and that includes not tainting a future jury pool. So that is a right that the judge needs to protect. And so what he's doing here is splitting the baby, essentially saying, I'll let some of this in, but not all of it, you know, and I'm redacting whatever 16 minutes of it. But I think at the end of the day, Chris, no matter how much of this comes in, we have to remember that one of the benefits of a preliminary hearing as opposed to a grand jury indictment to the defense is that we get to cross-examine important witnesses. Here we have a star witness who is not going to testify. And so this deprives the defense of the ability to challenge his testimony, lock him into testimony that they can then impeach him with at trial. And they don't get that. So it doesn't matter what part of this video or audio comes in, they don't get the live testimony. Yeah,
that is a very, very good and educational point that you just made for the audience, the difference between preliminary and indictment and why it's definitely better for the defense to do it this way, which is why I'm always shocked when any defendant waives a preliminary hearing. But let me ask you something, Sara. How do you balance, as a defense attorney, this guy did it, okay? So how do you balance what you're, I mean, the guy did it, Sara. The guy, he's got to have his day in court. It's got to be fair.
You always say that.
Yeah,
you always say that, no matter who the guy is. Okay.
The guy, but this guy did it, okay? When someone doesn't seem, I mean, it's just his demeanor. This bothers me so much. I feel the same way I do about Mangione. And I got to be transparent with the audience. You've got to do it the right way. You have to. The process must be right. So how do you balance that here, where finding probable cause will be easy, but going forward as defense counsel, what do you focus on here?
I mean, the focus really, look, this is a capital case, and it's really not about guilty versus not guilty. This is about saving your client's life, right? It's about getting LWOP. And, you know, I heard the other night...
Life without parole.
Life without parole, correct. And I heard the other night, my good friend Mark Eigelish was on your show talking about, I'll go buy my knee pads and get on my... No, we do not get on our knees. We stand up, we fight, we leverage, and we eventually negotiate. And remember Kohberger. Kohberger was also in a state where there was the death penalty. He was facing the death penalty. But at the 11th hour, after he fought for so long, for like 2+ years, he finally pled guilty. And the difference is that, look, you're in a state where you need 12 jurors unanimously to agree on death. That's something the defense has to whisper loudly and consistently in the prosecution's ears to get them to back off. I mean, do you really want to keep trying for death and take the risk that one holdout could not get you there? And then also, in any case, right, you want to get closure. You've got Erica Kirk saying, I don't want death. You know, an appellate, you know, situation can go on for years and years and years. And the way to do that and put a lid on it is essentially a plea agreement.
I got it.
So it's not about pleading now or never. It's about the right time. And I think what the defense is doing is paving the path towards trial, poking holes at the DNA, at the ballistic.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.